rather than the speakers. Precisely the same objections that my colleagues are raising here.
Yes.
What did the court answer that? How did the court answer that question? You find that answer in paragraph 54, 55, 56, 57, 58, 59, 60, 61, 62. Allow me to focus on just paragraph 56 because of time, but we'll find the answer in all those paragraphs. In our view, there are circumstances where the speaker could be a proper respondent in a suit. For example, where what is in issue directly involves the speaker, like where it is alleged in a suit that the speaker was not qualified for election as such under Article 106, Clause 1 of the Constitution, or where it is alleged that the speaker allowed the passing of legislation in utter violation of the Constitution. For example, here we have said the speaker allowed debate on matters sub judice. The speaker allowed debate on matters when there was a court order prohibiting those proceedings and the standing orders. A good example is found in the Speaker of the Senate and another versus the Attorney General, where the heart of the dispute was the acts and responsibilities of the two speakers. And you carry on and on. So that paragraph 58 confirms that the roles are vested in Parliament and not in the individual members of Parliament. And once you read it fully, you'll appreciate that the court appreciated where it is alleged that the National Assembly or the Senate have violated the Constitution, the Speaker is a proper respondent in the context of business. And therefore, this matter is a spent issue. How the respondent and each of the interested parties have come back to make this a big issue shocks us. But more importantly, at paragraph 62, the Court of Appeal then makes that an issue. It says even if there was misjoinder, it is not a ground for striking out or disallowing the petition. Paragraph 62. So the question I want to pose before you is the same question I've posed elsewhere. When the respondents are aware, in fact, Mr. Mawera expressly referred to this authority, meaning they are aware of it. And they are aware that this is a Court of Appeal authority. What do they want you to do about it? In this authority, the Court of Appeal has laid out before you the circumstances under which the speaker can be joined as a respondent, and those circumstances are on all fours with the matter before you. I think that ordinarily should be enough to dispose of this matter. But let me deal with the question of prejudice. One may also then need to look at the replying affidavit of the respondent. Both the replying and the further affidavit, but let me deal with the replying affidavit. It makes the point fully. First, the respondent files the affidavit through Mr. Jeremiah Nyegenye, clerk of the Senate and secretary of the Parliamentary Service Commission. It means the respondent understands very well that he has been sued not in his personal capacity as the speaker, but on behalf of the Senate of Kenya. That's why he's getting an officer of the Senate to swear the affidavit. At paragraph 2 of that affidavit, of both affidavits by Nyegenye, they are only paragraph 2. Mr. Nyegenye described himself as the custodian of the journals and records, whether audio, electronic, or any other form, including all papers and accounts, however presented to and belonging to the Senate. The respondent has replied through an officer who described himself as such, the alpha and the omega of Senate processes. So what prejudice has the respondent suffered? There used to be a law, a rule, I think it was of evidence or procedure, it's of procedure, my lord, that if a party unnecessarily causes another to prove an issue, even if he wins the whole case, he may be penalized to the extent of the cost of proving that issue. This is a kind of matter you may issue, what is called issue costs, because of this kind of behavior on the part of the respondents and the interested party. The second issue ruling here is on the hue and cry that has been made by my colleagues about whether or not there was a binding order of court. Again, Mr. Mukele preferred to leave this issue, the interested parties, for good reason. For good reason. Yes. He simply has no defense to this issue. That's it. He did a wise thing, that when you have no defense, you remind yourself, you know, I'm a professional, and there's a limit to which I can embarrass myself with some issue. You leave it. It is the interested parties who took the cudgels upon themselves, and we understand why. The interested parties, particularly my learned colleague Mr. Maweu, represents the contemnors in that contempt matter. So we understood why. But Mr. Mawera, Murerwa, I hope I got the name right, made a point that I'm still struggling to understand up to now. He kept saying that the order of Kasam J of 24th July 2024 was not a conservatory order. Yes. That's a strange way of approaching things. He didn't tell us what it was. He told us what it was not. I dare say he didn't tell us what it was because, my lord, had he been pushed to tell us what it was, he would have told us it was a conservatory order. Had he been pushed to now tell us what is, because it's an order. There is an order, undisputedly. What is it? He told us what it is not. I verily believe that Mr. Mawe would have told us this is in fact a conservatory order. Why do I say that? At the introductory paragraph, the court opens the ruling by saying, this court has to make a decision as to whether to grant an interim orders or preserve a status quo or not, pending the ruling on the petition filed by the governor of Meru County. An order preserving the status quo is a conservatory order. It has no other name in public law. There's no other name in public law. The court said from the outset, it is making a decision whether to grant an interim order or preserve a status quo. What is the name that we give orders that preserve the status quo? It is called a conservatory order. It has no other name. And therefore, when the court concludes by telling us that the upshot of the above is that the impeachment process is halted, this order must be seen in the light of the introductory paragraph, where the court had set out that it was determining whether or not to grant a conservatory order. But my lord, I also kept struggling. So what if it should not be called a conservatory order? So what? By whichever name you want to call it, it's an order of court. By whichever name you want to call it. It's an order of court. Whether you call it an injunction, whether you call it a stay, whether you call it a conservatory order, whether you call it a status quo order, it's an order of court. And that is what gives it the legitimating force. It's an order of court. As a consequence, it was the unqualified obligation of all concerned to comply with it. My learned colleagues have made an issue that I found disingenuous. They've said that we have raised this issue in Meru and we have raised this issue here. Nothing can be further from the truth. In the High Court of Kenya at Meru, the petitioner before you sought that the contemnors be cited for contempt and be punished as the issue. She succeeded. They were cited for contempt. They were punished. We are awaiting execution of the punishment. At the moment, they are fugitives in law, at law. That determined that matter completely. Before you, the petitioner has raised another issue. What are the consequences of the failure of the Speaker of the National Assembly, of the Senate? What are the consequences of the failure of the Speaker of the Senate to appropriately guide the House on the effect of that order to the proceedings before the Senate? A completely different issue. How my learned colleagues think that these issues are one and the same stretches my imagination. But my colleague, Mr. Mutuma, has an answer for me. He keeps telling me, well, if you have a case that is as bad as the one that they have, what will you do? You would say something. So we don't begrudge them. The third issue, so my lord, the issue that we have abused the court process does not lie. These are two distinct issues addressing very distinct matters.
Are there two petitions?
That is correct. Not on the same issue. Not on the same issue.
Does the other petition pending in Meru
Yes.
have an argument about section
33.8. Correct.
prayer for it to be declared?
Yes, I'll not come to that specifically. I'll address that issue specifically once I'm done with my next issue, because I'm coming to that, on the nature of sub judice and the nature of res judicata in constitutional petitions. I'm coming to that. But allow me to finish. There are two petitions. Print out for me the petition from Meru. It's here. So, my lord, if you look at volume 2 of the 5th interested parties replying affidavit, maybe the fifth, let me tell you the 5th interested parties replying affidavit. There is a page 48 of 3559. So it's a huge volume. Thank you so much. And if I may just quickly take you all the way to page 64. Yes. Let's look at the prayers, because that's where we determine what is the issue in that case. A declaration that the County Assembly of Meru, through the routine and perpetual impeachment motions of the petitioner, is guilty of exercise of its power in an illegal, excessive, and abusive matter. There's no such issue before you. There we are interrogating this perpetuity, because this is admittedly a multiple exercise of the same power. Number two, a declaration the petitioner has rights under Article 151, the right to fair hearing, because of the glaring partisan and biased nature of the County Assembly of Meru. A declaration that the past and present conduct of Meru County Assembly demonstrates lack of capacity to act independently. Not an issue before you. Then we have D, which is section 33.8. I'll come to that specifically. Let's go to E. The notice dated 15th July does not meet the threshold for impeachment set out in Article 181. And the Meru County Assembly standing orders hence the same B and hereby set aside an order of injunction restraining the respondents in any manner from discussing, debating, or anyway dealing with the removal of from office through impeachment. These are the issues in Meru. I will revisit the issue of section 33.8. Next. So if you look at the issues in Meru, there are issues that are preventive in nature. There are issues that are seeking to stop a threat to violations, which is a complete remedy in Article 22, Article 23 of the Constitution, a threat. There are preventive issues, there are medical issues. They seek to prevent death. The petition before you is a post-mortem. Is a post-mortem. So that the respondents and the interviewer are telling you that Why is the mortician looking at this body when the doctor also looked at it earlier? I mean, that's curious. The mortician's duty is distinct and separate from the doctor's duty. We have come here in a post-mortem to look at the Senate's acts and ask, are they compliant or are they violative? The axe has fallen. Allow me to address you on the issue of Section 33(8) of the County Government Act. Number one, nothing stops multiple causes questioning constitutionality of a law. A law. Nothing stops it. Number two, particularly because the parties are not the same. The parties are not the same. The county assembly is affected by Section 33(8), and therefore the cause against the county assembly can very well include a challenge on that section. The Senate is affected by Section 33(8), meaning the Senate, the action against the Senate can very well address that issue. Nothing stops the petitioner before you from filing a case against even the Attorney General in his capacity under the Constitution to challenge the constitutionality of this provision of the law. We are not seeking different factual findings on the same facts. We are seeking an interpretation of the law on this question. Once one court has determined this matter, one way or the other, that will be an authority before the other court. That will be an authority before the other court. In fact, my lord, the proper thing is to ask, what remedy does the law provide in ordinary litigation where a matter is filed before two courts sub judice? The remedy provides that you stay one and proceed with the other. Here we are fortunate that we are proceeding with this matter today before the matter in Meru is heard. The law does not provide for any drastic remedy than just proceed with one first. Finish it before you go to the other. That's all. So nothing turns again on the plea of Section 33(8) against the Senate because the same was pleaded against the National Assembly. If you look at the claims in the petition in Meru, they are unique, particularly the factual ones. They are unique to the conduct of the County Assembly in Meru. And therefore there's no way the Senate would have been made a party there. And if you look at the allegations before you, the factual allegations, they are unique to the conduct of the Senate through its foremost officer, the Speaker. So that should, by and large, dispose of that matter. May I get a reminder of my 30 minutes? I have no idea of anything more than my 30 minutes.
Yes, 23 minutes.
Thank you so much. Allow me to deal with now the issue of whether this court has power for merit review. Again, it's the way we read authorities. I think that is the problem. Let's go to the Sonko case that everybody has cited. You'll find it in volume 10 of the petitioner's documents at page 345. Volume 10. Yes. Volume 10 of the petitioner's documents at page 345.
You have a 10 and a 10.
We have 10 and 10A, yes, they are both authorities.
So you want 10?
10 now, 10, yes. Thank you. That case is at page 345, and that case will help me deal with two issues. So let me start with the issue of whether this court has power for merit review. I'm going there. I want to start by referring this court to page 384. First, let's look at paragraph 148 of that judgment. Let's look at how the issue is framed by the Supreme Court. How the Supreme Court frames the issue. Whether, yes, page 384 or now. Okay.
Yes.
Yes, let's look at how the issue is framed. Whether the charges were substantiated to the prescribed standard to warrant the appellant's impeachment. That issue as framed is a merits review issue. The issue itself. Because, my Lord, how else can the court answer that issue without asking, was charge A substantiated? Was charge B substantiated? Was charge C substantiated? That's a merits issue. So the Supreme Court frames a merits issue. Let's go to paragraph 149, where the court looks at the Nyaga-Wambora case that my colleagues have multiple times referred to. Again, the court approves of the standard in Wambora, that the standard is neither beyond reasonable doubt nor on a balance of probability. Noting that the threshold for removal of a governor involves gross violation of the Constitution, we hold that the standard of proof required for removal of a governor is above a balance of probability, but below beyond reasonable doubt. Again, the court is setting a standard for merit review. The court is setting a standard for merit review. Go to the next paragraph. The Court of Appeal in the above case also affirmed the elements identified by the High Court as constituting proof of the charges of gross violation. Number one, the allegation must be serious, substantial, and weighty. Again, once you begin looking at whether this allegation is substantial, serious, or weighty, that is merit review. That's not process. This is you're weighing the allegation. Then finally, page 385, paragraph 152. Page 385, paragraph 152. We maintain that the High Court received and evaluated the evidence presented to it in support and in rebuttal of the four charges. When a High Court has received and is evaluating the evidence before it in support and in opposition to the charges, is engaging in merit review. The court continues, the Court of Appeal re-evaluated the evidence before coming to its own independent determination. Again, merit review. To the principal question, can this court engage in merit review? The Supreme Court, by framing the issue as such, analyzing it as such, answers that question in the affirmative. Again, I want to ask, you have a Supreme Court decision before you. The respondent, the IPs are not telling you, what do they want you to do about these things I'm reading? At least they are my witnesses, I am not formulating them myself. These are edicts of the Supreme Court. The answer is, they have to live with it, that this court has jurisdiction for merit review. So to my learned colleague, Mr. Mukele, who said he was shocked that I said this court can engage in merit review, my answer is, it was not me. I was restating the law as enunciated by the Supreme Court. He should not begrudge me. Now, to the question whether the petitioner did not raise, we restrained ourselves from objecting at all. You notice we never objected even once when they were responding. And I hope my time has been frozen, because I don't think that's an objection, but let's see.
My Lord, in that case, the court is the principle governing the process of impeachment for removal of accountable member. My Lord, you know that country was have a habit of partially
Let's now put my conduct into question.
Just a moment.
And when you look at paragraph 161.4,
Yes.
the court correctly observed that the mandate, the removal of a governor is both a constitutional and a political process.
It's merit.
The mandate of the courts is restricted by the doctrine of separation of powers to determine whether individuals' rights, dignity, and fundamental freedoms have been preserved and protected in the process without usurping the powers and functions of the legislative branch of government.
That's correct.
Now,
That is the law.
Council, this is an extremely vital case. It's very, very case. Council O'Brien?
Yes.
Just a moment. Let me speak to you.
Yes.
We read 161 Roman 4. Please now read Roman 8.
Yes.
The grounds for impeachment and removal from office must be substantiated. The standard of proof is intermediate. That is, above a balance of probability, but below all reasonable doubt. And the proof of any one of the charges is sufficient to discharge the burden of proof. My Lord, I wish to clarify. And that is the role of the Senate. Not the role of the courts. When the Supreme Court states paragraph 161.8, it is the role of the Senate to substantiate just one ground. Nowhere does the court say it is the role of the court to find a class substantiation.
Now go back to paragraph 152.
Is what on there?
Now there's a very famous phrase, because this is cited quite a lot in constitutional petitions, as to what perhaps the trial court is the high court, the first appellate court, the court of appeal, and then what the Supreme Court can do. It starts with we cannot. It's in somewhere in the middle of 152. We cannot.
Substitute ourselves into the two courts and take up the roles of analyzing the evidence afresh for that time.
Now, if the Supreme Court is saying it cannot reanalyze the evidence, who analyzed the evidence? We maintain that the High Court received and evaluated evidence presented it in support and in rebuttal. Evaluated that evidence coming to its own independent determination. So let's agree on this. First of all, it is highly irregular. What you've done is have a rebuttal to a rebuttal. You're not objecting on a point of law, you're objecting to your interpretation of a Supreme Court decision. It is not as though you are saying that perhaps it had been a complete misquote, it had been overturned, etc. Secondly, and I did state this on Friday, there was a tactic that Councillor Ngoya invited the court to highlight and identify of breaking up their flow. Now, they did not object. Throughout your session, they waited. But let's do it differently. Let's go to paragraph 149. Yes. So the Court of Appeal in the above case, that is Wambora, which has been cited by your side extensively, the Court of Appeal, so it starts halfway down, the Court of Appeal in the above case also affirmed the elements identified by the High Court as constituting proof of the charges of gross violation of the Constitution or written laws as follows. The allegations must be serious, substantial, or weighty. There must be a nexus between the governor and the alleged gross violations. The charges framed must, and the particulars thereof, must disclose a gross violation, and the charges framed must state with a degree of precision the articles or even sub-articles of the Constitution or the other provisions of any written law that have allegedly been grossly violated. That is the standard that was affirmed by the Supreme Court. It is not going to change. How that is interpreted is not a ground for an objection. It isn't.
Precisely. When you read what your...
No, what you're doing is you're rebutting a rebuttal, and that is not proper. Yes, now I have to go to the sanction. Counsel, I'm going to fine you Kenya shillings 10,000. Please remind me of your full name.
Alex Bamble.
The court had previously warned counsel as to unnecessary and non-legally founded objections that have the effect of interrupting the flow of opposing counsel's submissions. This was done on Friday after repeated objections elongated the highlighting, which should have concluded on that day, but which
Sorry, my lord.
was spilled. Sit down.
Sorry, my lord.
Sit down.
My lord.
I'm giving a ruling. You do not. Yes, Mr. Kirimi, rise. Yes. Tell me why, where in practice, when the court is giving a ruling, do you interrupt the court?
My lord, our sincere apologies to start with.
No, just give me a precedent. Give me a precedent. When did we start interrupting the court giving an extempore ruling?
My lord, with a lot of ability, I thought perhaps we should persuade you otherwise, because
You can then say, after the ruling, after the extempore, you can then invite me to review. But you don't rise as I am giving the ruling and just start talking. Counsel, no, counsel, just listen to me. There is something that is happening to practice, and I think it is very unfortunate. It is very, very unfortunate. I practiced for 16 years before I became a judge. I have never seen, in 16 years, I have never seen anyone interrupt a ruling being delivered extempore. You wait until the end, you say most obliged, and then you say we would wish to apply for a review, stay, whatever it is, after it has been delivered. Let me give you an example, Counsel Kirimi, so that you can understand where I'm coming from. Assuming that a judgment was being delivered by a magistrate in a criminal matter, and you can tell when judgments are going in a particular direction, do you then just stand and just start talking over the magistrate? No. No, you don't do that. Now, so you've also attracted a 10,000 as well. So let's proceed. Sit down, please. Let me finish my ruling. If you want me to do anything, you will make an application after I've finished my ruling. So the court had previously warned counsel as to unnecessary and non-legally founded objections that have the effect of interrupting the flow of opposing counsel submissions. This was done on Friday after repeated objections elongated the highlighting, which should have concluded on that day, but which have spilled, that's where I reached, which have spilled over to today. Counsel Alex Mbaya rose on an objection that was in substance a rebuttal of the submissions in rebuttal that were being made by counsel Elisha Ongoya. The court gave counsel Mbaya time to articulate, but it became clear what his contention was, is that counsel Ongoya had misapprehended and misapplied the referenced Supreme Court judgment, and in particular the dicta on merit v. process review. That is not an objection, and consequently it is fit and proper that counsel Alex Mbaya be fined Kenya shillings 10,000 to be paid into the court by close of business 28th February 2025. Separately, and as this court was delivering its extempore ruling as above, at the point the ruling had turned adverse to counsel Mbaya. Counsel Kirimi, please to his feet and called and began to address the court in opposition of the court's extempore ruling. The court invited learned counsel to cite any authority that permits an advocate of this court to interrupt the delivery of a ruling in opposition of the same, rather than waiting for it to be completed, concluded, and taken the necessary action orally or in written application. Counsel was unable, and consequently this court finds him Kenya shillings 10,000 to be paid into the court by close of business 28th February 2025, dated, signed and delivered on this 24th day of February 2025, 19:06 hours. Yes, Council Kirimi. Yes, yes. Now you can rise.
Yes, my lord. My lord, first and foremost, I wish to apologize to the court and to my learned friends in this court.
Yes.
For perhaps what the court did not understand why I was rising.
Yes.
My lord, I didn't even speak. But my lord, I felt perhaps with a lot of humility, maybe the court did not look at the objection by my friend to be in good faith, which I don't think his objection was ill-intended or meant to obstruct our colleagues in their line of submissions. My lord, my intention was purely to request you for an indulgence. And to apologize, my lord.
Yes.
What perhaps has irked the court or annoyed the court.
Well, the court is not irked or annoyed. The court is confused as to when we started doing this. We see this on American telenovela, where counsel just shoots to their feet, the judge is talking and they interject. That's not how we do things in real life. Now, yes, sorry, have you? Yes, just proceed.
Thank you, my lord. And mine is to sincerely say that that was not the intention to obstruct your lordship or to appear disrespectful of this court or your lordship or of our colleagues in this humble profession. And my lord will be kindly beseeching you to consider the orders you've just given. With a lot of humility, your lordship, I urge you to kindly review them and set them aside as we finalize the hearing of this petition, so that your lord doesn't appear to any party that maybe we were gagged or orders were issued, the court was annoyed, and my lord, but we've taken the lesson that the court has given us, has reminded us. And your lordship, I wish to tell you that whether we are appearing before you or before any other court, the lesson the body does is well learned. Thank you, lordship.
Council Mbaya, do you have anything to say?
Thank you, my lord. I also wish to sincerely apologize to the court. And also wish to point out
Yes.
that my objection was not ill-intended. A lot of my expectation was that if this order of the court found that my objection was not merited, which was based in good faith,
Yes.
that this order of the court will be just overruled it and probably give directions as
Yes.
to what it will consider an objection on a legal issue. My lord, you remember last week, the objection that I raised was a legal issue, which this court upheld,
Yes.
and I also expected that this objection was a legal issue.
Yes.
which probably this court would have held.
Yes.
And therefore, my lord, whereas I, without any reservations, apologize to the court,
Yes.
and also seek that this court review its orders, I urge the court to make a finding as to whether it is open for the respondent and the interested party in opposition to the petition to raise any issues at this point which they consider may be misleading the court, because my lord, what we are doing is we are trying to help the court to come at a fair and just finding, so that, my lord, justice can be done in this case. My lord, we are always told that cases are not ours as counsel.
Yes.
Cases belong to clients. But as counsel, we are duty bound to do everything under the law to protect the interest of our clients. And sometimes counsel can go overboard in protecting those interests. Without, my lord, I apologize
Yes.
to the court and probably to counsel if they feel that the objection was without any merit.
Yes.
Seek request directions. I'm most obliged, my lord.
Court, I have heard the oral submissions by Counsel Kirimi and Counsel Mbaya, and it is undoubted that they expressed their heartfelt apologies for their respective interruptions. Consequently, I find it proper to review downwards the fine for each to Kenya shillings 5,000 each, to be paid on or before close of business 28th February 2024. That's 24th February, sorry, 2025, my apologies. 24th February 2025, 19:15 hours. Beyond that, if you're still aggrieved, there are options available. Yes, Council Angoya, my apologies. Just a moment, Council, just a moment. Just a moment. Please take your seat. Council Kirimi, and no, don't, please don't rise. We are still colleagues in this profession. It's just that I moved from there and I now sit here. You will recall perhaps in another matter you saw myself and my former deskmate, literally a deskmate, where I enforced the rules of the court, not because of myself, but because there is some dignity to being an advocate. There's a way we are supposed to behave, beyond the wearing the fancy suits. There's a way that we are supposed to behave, that someone seated at the back of the court can say, those are advocates, hao ni wakili. That expectation can never be diminished. So it is nothing personal, it is the rules. And believe me, you are living in a golden age of this, as Councillor Ongoya can confirm, because I think he's done more than 20, I've done more than 16. In days gone by, this would have been very different. There are cells at the bottom. That's what used to happen. I recall on the day of my admission, we were obviously very excited. We were threatened. A court assistant came out and said, if you guys continue making noise, all of you will go down to the basement. So it is not that I am irked, I am angry as an individual. I am trying to maintain the dignity that makes being an advocate special, that makes court proceedings solemn, orderly, and very somber, in a sense. Councillor Ongoya, you are at 2759.
That's okay. I'll ask you. There's one issue that was raised by the respondent, my last concern, that all these issues about found in two places. One is volume 2 of the petitioner's documents at page 16, where you'll find the program of the Senate for the hearing. And the time set aside as 11 a.m. to 11:30 was for preliminaries, but those preliminaries were prescribed. A, recital of the mandate of the Senate, rules of procedure and hearing program. That is by volume 2, page 16. Yes, so you see A, recital of the mandate of the Senate, rules of procedure and hearing. B, introduction of the members of the county assembly representing the county assembly and their council, if any. C, introduction of the governor of Meru County and council representing the governor. So the issue called preliminaries in this program is defined by the schedule. It's not an open-ended generic use of the word preliminaries. The second place where the answer to this would be found is in the Sonko case again, which is in volume 10, but this time around I'm looking at page 380, paragraph 132 that my colleague referred to. I'm trying to recollect who in particular referred to it. At the beginning of the hearing, the appellant raised a preliminary objection to the effect that the issue before the Senate was sub judice, as they were also the subject of some 4 active court cases, that there was a conservatory order issued in ERRC petition number 35 of 2020 prohibiting the county assembly and the Senate from proceeding with any motion for the removal of the appellant from office. The Speaker, in a reasoned ruling, directed that the objection be brought as part of the evidence to be presented during the proceedings. So the Speaker has already ruled that these issues are not raised as preliminary issues, that they should come out as part of the trial. Yes. And therefore, for the same Speaker and party supporting him to come here and say that we were wrong to raise them as part of the trial, that is disingenuous. But more importantly for me, we brought to this court's attention the fact that these orders were brought to the attention of the Speaker administratively by letter in advance of the trial, by the formal response of the governor in advance of the trial, by the affidavit of the governor in advance of the trial. so that to say that these issues were raised belatedly, or that the governor and her council acquiesced, as my learned colleagues refer to it, is not supported by the evidence on record. There can be no clearer protestation than the letter by counsel for the governor, than the response by the governor, by the affidavit in support by the governor, all of which go to the speaker ahead of the trial, protesting this trial, and eventually by in the closing submissions. Now, if you look at that trial process that we have looked at, as I close, just page what? You'll notice that at that trial, you got page 18. Yes, it's there. So at page 16 of volume number 2, as I finish, you'll notice that there were 2 hours. There were 2 hours that had been set aside from 4:30 p.m. to 6:30 p.m. deliberations by senators. And the question will arise, my lord, so what were the senators supposed to deliberate on before voting? Before, because you look at it, after 6:30 then there is voting. I submit to you respectfully that all these matters, including whether the matters are sub judice, whether the house is barred by a court order, were to be considered as an integral part of these deliberations before voting. And therefore that the conduct of the speaker in giving 3 minutes for this process, and that doesn't mean being taken away by the noise in the assembly, the loud consultations, that would be politically correct to the Senate, the loud consultations in the Senate, therefore took away that opportunity for these matters to be considered, and it was purely within the speaker's domain to ensure that he upheld this time so that the governor has the benefit of consideration of all these matters. Allow me to admit my colleague, Mr. Mutuma, to pick up from there. And my apologies, my lord, you notice my voice is very bad because I have a bit of a cold. My colleagues here have taken the risk voluntarily of sitting next to me.
Yes, my lord, I will not exhaust the 30 minutes because much has been covered by my learned senior. I'll just address you on some of the issues that have not been addressed. One, in response to my learned friend Mr. Mukele's submissions, I wish to state that Article 19 and 20 of the Constitution demands of a duty bearer to ensure that any right under the Bill of Rights is enjoyed to the greatest extent. We submit, Your Lordship, that it's not just a matter of crossing all the T's and dotting all the I's. The duty bearer, in this case being the Senate, has an obligation to go out of their way to eliminate any visible obstacles that may hinder the enjoyment of a right that has been provided for. Especially if that right is a right under Article 25 that cannot be limited. Your Lordship, the Act